Good day, Crime Talk aficionados. We have another great show for you today. First, 16 children, ages 18 months to up to 18 years, found
Very seldom would I ever allow somebody out on bond who I felt was incompetent. It's just too difficult actually to do a competency when they're out. That statement from a retired OO judge isn't just judicial philosophy. It's a warning, and it came after a 73-year-old grandfather accused of helping to hide 16 children in conditions described as deplorable walked out of the Southeast Ohio Regional Jail on a signature bond. He signed a piece of paper promising to $300.
You came up on my feed all of a sudden, and they said, oh, I guess I wasn't subscribed. You have to check the little bell, ladies and gentlemen. Sometimes YouTube turns the bell off, so go back and check it, please. Do it like your Crime Talk show depends upon it. Because, let's face it, we don't get enough views. You got to wonder, what am I doing this for? So please, if you like the show, come check us out. All right.
If he fails to appear, a sum no one believes he possesses, and was released into the community. This happened weeks after his own attorney filed a motion questioning whether Gary Siders Stir could even understand the charges against him. The same attorney who told the court his client suffers from significant confusion.
Well, guess what? If there's anyone here in the United States you want to check out, you can go to crimetalksearch.com and get that done. You're going to get a report. It's going to be emailed to you literally while you wait, within minutes, and you're going to find out everything. Email addresses, phone numbers, social media presence. You're going to find out if they're married, divorced, liens, judgments, criminal history, sex offender registry, everything you want to know about somebody that's going to come into your life. Listen, if you're dating, don't commit dating malpractice. Go check them out. You're going to find out more information than you ever would with a quick Google search. I guarantee it. CrimeTalkSearch.com. You're going to be happy that you did. All right, ladies and gentlemen, let's go ahead and open the record for August 4th, 2026. And we begin with the case that continues to hold the true crime community's attention every single day. And that's the trial of Lindsay Clancy. So on the sixth day of testimony there in the Plymouth Superior Court, the 35-year-old former labor and delivery nurse spoke on the record for the first time. Now, this was outside the presence of the jury, the 18 members to be exact, 12 jurors and 6 alternates. Well, Ms. Clancy answered the judge's questions and agreed to stipulated facts regarding the chain of custody for the physical evidence.
About the process, an inability to discuss with any sort of sophistication the legal process, and a general lack of confusion that made him unable to assist in his own defense. That man is now free. Picture a GPS ankle monitor strapped to the leg of a man whose attorney has publicly argued he lacks the mental capacity to understand why he's wearing it. That monitor is the visual anchor of this case, a piece of technology designed to track someone the state has deemed too expensive to keep, but not dangerous enough to hold. It is the physical manifestation of a system that could not decide whether Gary Siders served.
Confined in a small room under conditions authorities called deplorable. Their 33-year-old mother is now asking an Ohio court for a competency evaluation, and if she's found competent, an insanity evaluation. Meanwhile, an OnlyFans model, Courtney Clenny, has reached a plea deal in the stabbing death of her boyfriend. Lindsay Clancy, the former labor and delivery nurse charged with murdering her 3 young children, spoke on the record for the first time in her trial today. And Luigi Mangione, accused of killing the United Healthcare CEO Brian Thompson, is demanding that his murder trial be broadcast live for the entire country to watch. Plus, the Iowa woman who allegedly shot a man from behind during target practice and told the police it was either him or me. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and make sure you hit that little bell for notifications. We get more comments from people in the comment section saying, hey, I hadn't seen or heard your channel in a while.
Was a threat or a victim, competent or incompetent, a danger to the community, or simply too costly to care for? That ankle monitor is tracking a man the court hasn't even determined can comprehend the proceedings against him. Before we go deeper into what the documents actually show, make sure you're subscribed to Crime Files 91.1, because we don't just cover the story, we follow the evidence. The release of Gary Siders Stir raises a question that cuts to the heart of this entire case. The county prosecutor stated publicly,
the defense shortens the prosecution's cases and forces the jury to focus almost entirely on the mental state, the precise battlefield where postpartum psychosis cases are won or lost. Now, the prosecution's strongest card remains the methodical nature of the acts and the fact that she sent her husband out of the house first. We will be watching closely as the experts testify. And remember, you can watch it here on Crime Talk.
First, let me stress the community is not at risk because of this bond, that Mr. Sider Sr. has a serious medical condition that requires specialized care in a hospital outside of this area. But here is the contradiction. If his medical condition
strangled her 3 children, Cora, who is age 5, Dawson, age 3, and 8-month-old Callan with exercise bands in the basement of the family's Duxbury home. She then cut her wrists, and neck, swallowed some prescription pills, and then jumped from a second-story bedroom window. Now, the fall caused some complex spinal fractures that left her partially paralyzed and basically is wheelchair-bound. Her then husband, Patrick Clancy, had left the house at her request to run some errands. When he returned, he found a bloodied bedroom, an open window, his wife on the ground below, and the 3 children unresponsive in the basement. He called 911 and told the operator she's killed the kids. Now, the 2 older children were pronounced dead that day. Callan arrived at the hospital in cardiac arrest and was placed on a ventilator and died 3 days later. Now, the central issue for the jury is not what she did, it's whether she was criminally responsible when she did it. Now, the defense argues that she was suffering from postpartum psychosis, complicated by multiple psychiatric medications and undiagnosed bipolar disorder, and she experienced a command hallucination telling her to kill the children so that she could then kill herself.
is so serious that he cannot be held in jail. How can he be competent to stand trial? If he is not competent, how can he be released on bond to await trial? And if he is not a danger to the community, what does that say about the severity of the conditions under which 16 children lived? The system hit its limit. That is the moral refrain that will echo throughout this case. The prosecutor's office offered a chillingly honest explanation for the releasee. His medical care could potentially bankrupt Vinton County. Vinton County, Ohio, operates on an annual budget of approximately $8 million. The cost of caring for a 73-year-old man with serious medical issues in a county jail was simply more than the county could afford. So they released him. Not because they believed he was innocent. Not because they believed he was competent. Not because they believed the community was safe. But because they could not pay for his medical care. This is not justice. This is accounting. Retired Judge Robert Ruhlman.
Them too. But you would think somebody would notice that nobody's showing up for school or hasn't been there in a long time. Something, I think, went wrong, or somebody didn't say something at all. I don't know. We'll have to check it out. Next, let's move on to some self-defense claims. So the OnlyFans model, this woman, Courtney Clenny, has reached a plea agreement in the second-degree murder case stemming from the 2022 stabbing death of her boyfriend. Now, it's been a while, but back on April 3rd of 2022, inside the couple's apartment at the residence in Miami's Edgewater neighborhood, Christian Omboselli suffered a knife wound to the chest and later died at the hospital. Clenny never denied causing the injury. She has maintained that she acted in self-defense. And according to her account, Omboselli pushed her and threw her to the floor. She then grabbed a knife and threw it from approximately 10 feet away, striking him in the chest. Her defense team prepared to present evidence of ongoing abuse in this little tumultuous little relationship. Prosecutors disputed the self-defense claim, but on July 31st, defense attorneys confirmed that an agreement had been reached to resolve the charges without a trial. Now, the specific terms have not yet been disclosed and will not become final, obviously, until they are mentioned in open court and approved by the court. Clenny is scheduled to appear in the Miami-Dade Circuit Court on August 10th before Judge Wolfson to change her plea from not guilty to guilty. Sentencing is expected to follow immediately if the judge accepts the plea agreement. Now, both families are expected to attend. Clenny has remained in custody since her arrest in 2022 and faced a potential life sentence if convicted. Now, obviously, the critical question is in any self-defense claim is whether a reasonable person in that moment would have believed deadly force was necessary to prevent imminent serious harm. Throwing a knife from 10 feet away raises specific factual issues a jury would have had to weigh considerably. Now, in this case, does the distance and the act of throwing the knife change how we evaluate the
who sat on the bench in Hamilton County for 36 years, told Crime Fix that he would never have allowed such a release. Very seldom would I ever allow somebody out on bond who I felt was incompetent. It's just too difficult actually to do a competency when they're out. He noted that competency evaluations require observation, monitoring, and control. Exactly what is lost when a defendant is released into the community. And he raised the uncomfortable possibility that Gary Sr.'s incompetency might be feigned, a tactic defense attorneys use when the facts of a case are overwhelming. A lot of these defendants fake it
911 and claim self-defense. In statements to law enforcement, she said, "It's got to be now or it's going to be me. It was either him or me, and I didn't want him to suffer." Now, investigators reported that Ruland was uninjured and that there was no evidence indicating she was in danger from Emick at the moment that she was, in fact, fired the shots. The bullet wounds were consistent with shots fired from behind. Trust me. I've done that case. It's tough to claim self-defense when people are shot from behind. All right. Anyway, court records note that Ruland has been staying with Emick for several days and was the protected party in a protection order against him. Now, prior to the incident, she had told family members that she wanted a gun for protection and that Emick was going to teach her how to shoot. She was arrested the same day and is being held without bond. The investigation continues. Once again, we see a self-defense claim. Here's the physical evidence: shots fired from behind and no injuries to the shooter. That's going to be central, right? Under Iowa law and in most jurisdictions, the threat must be imminent. And a prior protection order can supply some relevant context, but it does not automatically authorize deadly force once the protected party is no longer under immediate attack. So, should a prior protection order weigh heavily when the physical evidence shows shots fired from behind? Let me know what you're thinking. Also, why are you there at the house if there's a valid protection order? You can't use it as a shield and a sword, ladies and gentlemen. Next, how about Luigi Mangione? That's right.
Ruhlman said, "They try to fake it. A good examiner will have them watched and review video of them when they're not there and pretty much clear up the faking. The system hit its limit." Gary Siders Stern is not the only defendant raising competency issues. All 4 adults in that household
bring you literally every day, every second the court is in session, we have it streamed live. But let me ask you this. Do you believe postpartum psychosis can completely erase criminal responsibility, or should it only serve as mitigation when we get to sentencing? Drop your thoughts in the comment and I will check them out. Now we turn to another case in which mental competency sits at the center of the proceedings. That's right, Elizabeth Siders, the 33-year-old mother of 16 children. So on June 30th of this year, officers in the village of Hampden, Ohio, serving an unrelated arrest warrant related to some public indecency charges against her husband, opened a door and discovered 16 children ranging in age from approximately 18 months to 18 years. Police described the conditions as absolutely deplorable. Investigators reported that the children had been confined to a small room, had not been attending school, and that some...
Gary Sturr, his wife Christina, his son Gary Jr., and his daughter-in-law Elizabeth have now filed motions requesting competency evaluations. Elizabeth Siders' attorney, Thomas Stoley, filed his motion on August 4, 2026, writing that, during these interactions, counsel has been able to observe the defendant's demeanor, conduct, and comprehension. These interactions lead counsel to believe that the defendant may be suffering from significant mental health issues, and that competency may be an issue and a clear impediment to the defendant's ability to assist in her own defense. The pattern is unmistakable. Every adult in that house is now pursuing the same legal strategy, creating a wall of competency claims.
His defense, led by Andrew Hamilton, argued that the truth should be a defense against libel charges. The jury acquitted Zenger, establishing an important early precedent for freedom of the press in America and influencing later First Amendment principles. Now, nearly 3 centuries later, Mangioni's defense team is arguing for maximum public access to a high-profile murder trial. Obviously, the tension between the right of the public to see the trial and the right to a fair trial remain very much alive. The question then becomes will Justice Caro expand media access or keep the cameras out? Now, we'll be watching that ruling very closely, all right? You know my position. If you've been following for a while, I think cameras should be in every courtroom for every minute that the court is in session so that everybody has a right to see what's going on. The public has a right to see what's going on. And in today's world, why do we not use technology so that everybody can see if the prosecution is acting righteously or is the defendant getting screwed by either not having effective representation, the prosecutor acting unethically, or maybe they're doing everything great, and is the judge being fair and impartial to both sides, calling balls and strikes? Who would have a problem with that? It's like all things in life, ladies and gentlemen, right? Light disinfects. You can see the little cockroaches run when the cameras go away. Turn on the light, watch the cockroaches run. People should want everything to be in the public when it comes to these court proceedings.
That could delay and potentially derail any accountability for the conditions in which 16 children were forced to live. But here is the problem. The prosecution has stated repeatedly that the family was hiding the children. They were once enrolled in school and then they were not. They were reportedly homeschooled, but there is no record of that homeschooling being registered or monitored. The children were confined to a small room, deprived of education, medical care, and the basic necessities of childhood. If the adults were competent enough to hide the children, to conceal their existence from the outside world, to maintain the appearance of normalcy when it suited them, how can they now claim they were incompetent to understand the wrongfulness of their conduct? The act of hiding suggests awareness. Awareness suggests capacity, and capacity suggests criminal responsibility. The ticking clock moment in this story is not about a deadline or a countdown to a trial date. It is about the ongoing consequences for the 16 children who were rescued from that house. They are now in state custody, but their recovery has only just begun. The psychological damage inflicted by years of confinement, neglect, and deprivation does not disappear when a social worker opens a door. It lingers, it manifests in developmental delays, attachment disorders, behavioral problems, and a host of other challenges that will require years of therapeutic intervention. The children are safe now, but they are not healed. And the question that hangs over this entire case is this: while the adults play the legal system, filing competency motions and arguing about mental states, who is fighting for the children? The release of Gary Sider's sister on a signature bond is a decision that will be scrutinized, questioned, and debated. But it is also a window into something larger. It is a window into a system that is so underfunded, so overwhelmed, so desperate to cut costs that it would release a man it has not even determined is competent to stand trial, simply because it cannot afford to keep him. It is a window into a county so poor that it would rather risk a 73-year-old man vanishing into the wilderness of Vinton County than pay for his medical care. And it is a window into a legal strategy that is so predictable, so transparent, that even retired judges recognize it for what it is. The system hit its limit. The motion filed by Elizabeth Sider's attorney is a public record. It is available through the Vinton County Court of Common Pleas, and it lays out in detail the arguments that the defense will make regarding competency and insanity. Anyone who wants to understand the legal strategy in this case should read that motion. It is the foundation upon which the entire defense case will be built. And here is the question for you, the viewer, to answer in the comments. If you were the judge in this case, would you have released Gary Sider's sister on a signature bond, knowing that his own attorney has questioned his competency to stand trial? Where do you draw the line between compassion for a sick elderly man and accountability for the conditions in which 16 children were forced to live? What would justice look like for the children who lived through the Ohio House of Horrors? This is Crime Files 9/11. We don't just cover the story, we follow the evidence. If you found this analysis valuable, like this video, share it with someone who needs to understand what's really happening in this case, and subscribe to Crime Files 9/11 so you don't miss our next deep dive into the documents that matter. And don't forget to hit that notification bell, because in cases like this, the story is never over, and the next filing could change everything. The ankle monitor is tracking Gary Sider's seer as he moves through a county that couldn't afford to keep him. The competency evaluations are pending. The legal battle is only beginning. But the 16 children who lived through the Ohio House of Horrors are still waiting for justice. And that is the fact that should haunt every lawyer, every judge, every juror, and every citizen who learns about this case. The children lived through it. Now it is our turn to live up to our obligations to them. This is Crime Files 911. Subscribe, follow the evidence, and never forget the children.